Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about conditions of probation and how you could violate your probation without committing a new crime. A lot of times, clients that we have, they'll be placed on probation, they'll have a probation officer, or even prospective clients. Maybe we didn't represent them in the original case, but they're accused of violating probation. They'll come back and they'll say, wait a minute, why am I being accused of violating probation when I did not commit a new crime? I'm not being charged with a new crime. And our answer is very simple. Sometimes conditions of your probation involve, remain law-abiding. Other times, they're just specifically tailored criteria or rules that you need to follow if you want to stay out of prison. And, you could, violate your terms of probation. And if I did it, or if someone who's not on probation did it, it wouldn't be a crime. And if you did it, it would not be a crime, a new offense, but it could be a violation of your probation. You're not being charged necessarily with a new crime just because it's alleged you violated probation. Sometimes you are. Sometimes it's obvious. You pick up a new case, you got your new case, you got your violation of probation on the old case. But other times you don't need to be charged. It doesn't even need to be an offense alleged. You could, if you violate a restraining order, arguably, that's a whole new crime. If you're out past curfew, if you're testing dirty when you're not supposed to be, taking certain pills or certain drugs without a prescription. If you're consuming alcohol, and that's a condition of your probation. Consuming alcohol over the age of 21 is not a crime. Consuming alcohol over the age of 21 on probation, if you're prohibited to do so, is not necessarily a crime, but it would be a violation of probation. And then you're subject to what you could have gotten originally. So if your max was like 5 years by the plea deal, even though you got probation, you could still get up to 5 years now if you violate probation. So I want everyone out there to understand that just because you did not commit a new offense, or just because you're not even alleged of committing a new crime, does not mean you're in the clear as it relates to probation violations. And the other thing you need to be mindful of is that if you're accused of a probation violation, whether you did it or not, whether they can prove it or not, you're under no obligation to talk about it. Reach out to a locally experienced quality criminal defense firm and say, hey, this is what I'm being alleged of. I did it or I didn't. I think there's going to be some evidence here or I don't. Right? Have that confidential case evaluation, what your options are, where you are now, where you want to be, how this case could affect that. Before you start going and trying to justify it or start making up excuses and start talking about, the alcohol monitoring device, I had mouthwash 6 hours ago. That's ridiculous. That's ridiculous. If there's a viable argument to be made there, let your attorney make it after consulting possibly with an expert on that issue. So keep all these things in mind when you're on probation. You don't need to commit a new offense, new crime, to be accused of violating your probation. And if you are accused of violating your probation, politely decline to answer any questions about it. Reach out, or have your family reach out and consult with, and then hopefully hire, if you can afford to do so, a quality, locally experienced criminal defense firm to help you through that probation violation, particularly felony probation violations. Any questions, feel free to give my firm a call. Again, my name is David Shapiro. I'm a San Diego criminal defense attorney, 619-295-3555.